Any doubts from the last class? Anyone? No? I'm teaching well. Good evening, Tejaswini. All right. So today we will be covering National Judicial Appointment Commission controversy. And with this, let's get over with the jurisdiction of the Supreme Court. So what will happen in the 6 classes now? We will have very good understanding of Supreme Court from pre and main examination perspective. How many of you are aware about a recent notice which the Gujarat High Court has sent to the government of the state? Yesterday something happened. Anybody? It's a very progressive. No idea. All right, homework. Homework. So let's start with a question. This was asked in the UPSC examination. Till other people join, then till then we can have our own classes. Okay. So there is a question which was asked. I want all of you to try it. All right. Ready? Let's try this UPSC question. It's a pre-examination question. The question is, so it is about power of Supreme Court. So power of Supreme Court, and then the question reads that this power of Supreme Court to decide disputes between center and the state, to decide dispute between center and state falls under which jurisdiction? Do you need an option for it? We have covered it in the last class. Under which jurisdiction? Very good. It is the original jurisdiction. All right. So is this a difficult question? क्या टुच्चू सा सवाल पूछ रहे हैं बताओ? Is it a difficult question? All right. Let's make it a bit more difficult. So sometimes what they do, and this is actually a problem with method of teaching as well. So as per the Indian Constitution, there are many parts, and many parts contain different articles. You all are aware about it. So original jurisdiction is mentioned in article as per the Supreme Court part is concerned. So we go 131, 132, 33, 34, 34A, 35, special leave and all of that things join in. But then there are some other parts like something related to Finance Commission, issuing writ. All right. So these also fall under certain jurisdictional idea. Jurisdiction is basically, jurisdiction refers to the area or the territory in which a court can exercise its power. Right? Think like this. So there is something called a term jurisdiction. So when we use this term jurisdiction in polity, we are referring to a territory, or let's say an area, to make it more simple. And what this area is, the entire area in which a court can exercise power. And because the power is legitimate, so we will say authority. Because this term is about jurisdiction, many times there are some questions that will confuse you. So if UPSC is asking question like what falls under original jurisdiction, suppose this is the question, then in this question, not only what is mentioned in the chapter of Supreme Court will fall, the article that is concerned with, we will come to it later, but also other areas. So for example, writs to some extent, something related to Finance Commission, etc., will fall under this. But suppose instead of asking about jurisdiction, the UPSC focuses on the article. Whenever the article is coming, limit yourself. Because if you will not limit yourself, what will happen? You will think that they are asking about every kind of jurisdiction which falls under the original category, and then the answer could be wrong. So don't fall for this mistake. If they are mentioning some article, be specific to the article. Sometimes in an article, a question could be framed which is going to confuse you. And whenever those questions are asked, always refer to the major text of the Constitution. Now, after this year preliminary examination, many of the questions came from the syllabus. Many students are asking this key, oh, the institute is not working well, and in other institutes it is being questioned. Students are questioning that their preparation is not going well. So stick to the syllabus and stick to the Constitution. Try to answer this question, and then I will ask another question which I had given all of you as a homework in the first class. So here is this question. Try to figure it out. What will be the right answer? The question goes like this. So it is, which of the following are included in the original jurisdiction of the Supreme Court? Which of the following are included in the original jurisdiction of Supreme Court of India? This is the question. Option number 1. And with each option, I want you to answer. A dispute between Government of India and one or more states. So it refers to a dispute. And this dispute is between Government of India and one or more states. Now tell me, is this option correct? Before moving on to the next option, tell me, is this option correct? So we take it in, okay? This is correct as per my students. Let's look at the second option. The second option is, and it's related to elections and parliament, a dispute regarding election to either house of parliament or that of legislature of a state. Dispute regarding elections to either house of parliament or legislature of the state. What is your take on this statement? Is this going to be part of original jurisdiction, which I have taught you so far? Difficult? Confusing? All right, so when I said no, let's look at the third option and read very carefully. The third option is a dispute between Government of India and a union territory. So again, dispute between Government of India and a union territory. Is this fall, or does this fall under original jurisdiction of the Supreme Court? Manjot is saying yes. Anyone else? Difficult? Nakul is saying also yes. All right, let's move on to the fourth option. The fourth option is dispute between two or more states. So again, dispute between two or more states. Does this option also fall under original jurisdiction? Fourth one. So according to you, what is the right answer? 1, 2, 3 and 4 option. Let me give you some options. Option A, let's say 1, 2, 3 and 4. Option B, let's say 1, 3 and 4. Option C, let's say 1 and 3. Option D, let's say 1 and 4. What is the right answer? 1, 3 and 4, 1, 3 and 4, 1, 3 and 4. Anyone else? Okay. You are wrong. Confused? Leave this option, Abhi, huh? There is something related to it, but not as like original jurisdiction. So let's leave this option. Why this option is incorrect? This is a wrong option. It's not correct. Any guess? I have given you a homework about Delhi and all. Sabha is saying 1 and 4. Yeah, 1 and 4 is the right answer. But now tell me why option number 3 is not correct. Okay, think like this. In India, a union territory, it's already union here, right? Government of India is also of union. So basically, we are having a dispute at the same level of government, isn't it? Okay, Sahbaz, your answer is partially correct, that UT is not part of state. We will come to it in a while. It's a very important question, and a main examination question is also possible from this part. See what happens. The government of India, which means the executive, is headed by the president, right? And as far as the governing of union territory is concerned, someone appointed by the president governs the territory. Yes or no? You all have gone through president part, right? So basically what we are having here, same level of government and a dispute there. So it's not two parties, isn't it? But there is a problem. The moment I bring in Delhi, now suppose instead of UT, there was NCT of Delhi. Let's change the question. Okay? Instead of UT, let's write NCT of Delhi. Now, what is going to be the right answer? These four. Try गलती बोलिए. Is it A? Is it B? Is it C? Is it D? 1, 2, 3 and 4, 1, 3 and 4, 1 and 3, 1 and 4. Except, so now if you bring in Delhi, then as per the Supreme Court, this option is correct. Third part comes in. So understand what is going on here. The term state has a meaning. On one hand, basically what it matters is, what it means precisely is that in the federal structure of India, there is a central government and there is a state government. When looked from the principle of federalism and the nature of federal government, Indian constitution has developed with subsequent amendments, Delhi falls as per functionality. Okay, in terms of functionality, Delhi falls or is under the ambit of a state as per original jurisdiction is concerned. This is how the court is deciding matters. So they are going to understand whether a specific entity is eligible to be counted as a state or not. This is what happened when there was a tussle between Government of India through LG and the Delhi government, NCT of Delhi. There is one more point here. The court is clear. State means, in terms of government, there has to be a council of ministers. And then the executive head, even at the state level, must act on the advice of council of ministers to some extent. Delhi fulfills that criteria as well. There is a council of ministers in Delhi. Under Delhi government, there is a ministry here. And then the lieutenant governor has to work through advice, all right? It's not going to just give command, because the larger structure of the constitution, or let's say the basic structure of the constitution, is in favor of a democratic representative government and not an executive government per se. The government nature has to be democratic, even if it is led by an executive head. That is why if I bring in NCT of Delhi here, the answer will change. So whenever UPSC is asking you question, be very careful in reading the options. All right, clear? Shall we move ahead? Okay, इसको मिटाते हैं. Let's try one more question. So Always be careful, huh? Be careful of the words. Take some time, read the question carefully, and then try to answer it. Okay, let's look at one more question, a very easy question. Very simple question. So, the question is, and it's 2020. In India, separation of judiciary from the executive is mentioned in which part? Question is, separation of judiciary from executive is mentioned in which part? Do you need option for this? What is going to be the answer? Is it going to be the preamble, directive principles, fundamental duties, or let's say 7th schedule? Good. It's directive principle of state policy. So there are some questions which are traditional polity facts, and then there are some questions which are conceptual polity facts. Both kind of questions are asked by the Union Public Service Commission. ठीक है? तो स्ट्राइक रेट कितना रहा? 3 में से 2 सही. ठीक है, अच्छा स्ट्राइक रेट है. Okay. Let's move forward. So where were we yesterday? We were discussing the collegium system. We were in the idea of independence of judiciary, and under this heading there was one factor, which is that if the formation or constitution of judiciary is based on independent nature, which means that there is less executive control, there is less legislative control, there is less popular control, or even if following the executive part, there is check and balance, independence of judiciary is ensured. This is what we have discussed. In this, we discussed that with time, post 1981 and with 1993, the Supreme Court of India developed a collegium system. And this system was further reiterated in 1997, and till then it is followed. Many people are asking question about transparency. So the major issue is about transparency. All right, or let's say secrecy behind the reasons or criteria of appointment of judges. This is what we have discussed so far in the previous class. Let's have a bar here. Now we have to discuss collegium system in relation to National Judicial Appointment Commission. Often in the main examination, when they ask question about reforming the judiciary, they go with this topic, appointment commission. In your copy, write main examination. So the fourth question that we're going to discuss today is about this topic. So what happened? A quick revision of the collegium system. Through 3 judges cases, 1993, 97, and before that 1981, especially through 1993 and 1997, the Supreme Court, without any mention in the text of the Constitution, developed through a progressive reading a system of appointment. This system is known as collegium system. In this, the Chief Justice of India, Honorable Chief Justice, with 4 senior most judges of Supreme Court, decide on the matter of appointing judges in the Supreme Court, transfer of the judges, and promotion of the judges. Now the major issue here is that on what grounds are these judges appointed? There is a risk of discrimination. It is possible because too much of concentration of power could lead to tyranny of power. This is how polity is structured. Then there is a question of emerging questions like, if we look at the subordinate courts and also if we look at high courts, we find that many judges have often come under scrutiny, critical scrutiny, and many honorable judges, people have alleged that there were discrepancy involved in their conduct. The only judge who had gone through impeachment process was working in capacity as a judge in Punjab. So we have a judicial case as well, and the internal inquiry of judiciary found him guilty. So if we are saying this, that despite all the provisions of the constitution, and despite that the honorable judges are taking due care of appointment of other people as the judges, there is a possibility that corruption could prevail or injustice could prevail. In order to ensure that this system is changed, the government thought of bringing something new to it. So, why they brought it? All right, so let's begin with the challenges which are faced as far as collegium system is concerned. The first issue is that under the collegium system, there is lack of transparency and accountability. This is the first argument or first issue about the collegium system. Transparency and accountability. What do we mean by transparency here? Very simple. The ground or rationale behind appointment is not clear. What is the matter of accountability here? Very simple. That after appointment, if there is a question of misconduct on part of the appointed judge, no question is asked to the people who appointed, or let's say asked to the collegium system. So this is the first problem. The second problem deals with, from here, rationale, lack of formal criteria. Lack of formal criteria. So for example, if you think about, let's say, the examination you all want to clear, Union Public Service Commission examination. There is going to be a pre-exam, then a main examination including the personality test, then there is training, and then you are qualified to become an IAS officer or other rank officer, and then you are deployed. If you think about Parliament, in the Parliament, we have procedure like proper elections, then there is a counting done by an independent body, Election Commission of India, and then there are other motions as well. So there is a criteria, there is a formality of the procedure. As far as appointment of judges is concerned, we only have criteria that qualify someone to become a judge, but no other criteria as such. And whereas other appointments are concerned in other institutions of the government or other organs of the government, for example, executive and the legislature, we have both criterias that make one qualified to be appointed or to be recruited, but also other rationalities, right? So you have an examination, there are other things, and then there is proper process of internal inquiry and external inquiry as well. As far as judiciary is concerned, definitely a person needs to be advocate and etc. etc. But the final appointment, there is an element of discretion. There is a charge of element of discretion. Charge of element of discretion. This was the second issue which was raised as far as collegium systems problem is concerned. Third was about verification process, or let's say, taking cue from the previous here, that how to verify that the person who has been appointed is actually able and has integrity. So there is no clear-cut indication about verification process. And then the fourth problem or the charge against the collegium system is about question of representation. And we are very fortunate that at present the Honorable Chief Justice of India has noted this point as well in some other manner. So I think some of you must have heard CJI's statement that there is lack of women judges. Have you or have you not? That there is a lack of women judges in the judiciary. the share of women judges, right? Recently, United Nations has come out with a report about representation of women across polity economy in different countries, and there also our ranking is not that good, including in comparison to our beloved neighbors. So if you go to Bangladesh, and even for that matter to some extent Sri Lanka and Pakistan, our ranking is not that good. So it's a challenge for us to ensure representation. There is some evidence on this claim that there is a social representation issue. One is that the judges of subordinate courts, all right? So the judges of, let's say, subordinate courts, they are not able to get promoted to the level of Supreme Court and even High Court. There is one issue about subordinate court judges. Then the second issue is very important about women. For example, if you look at the data, all right, and this data is promising, it's ratified. If you look at this data, for the first 37 years of Supreme Court of India, so think about it, 37 years, for the first 37 years of Supreme Court of India, there was no appointment of a single female judge. It's a big question. If we move further and we further look at the data, the first case comes of Honorable Woman Fatima Bibi, who was promoted and appointed as the women judge. Then, if you look further, if you go from, let's say, mid 1985 to 2010, so mid 1985 to mid 2010, only 4 out of 127 Supreme Court judges were female, were women. So it's a very small number, isn't it? So the claim that there is an issue of representation of different sections of society, which is your UPSC topic about women empowerment and social rights, that claim, as far as data is concerned, turns out to be true. Moreover, there is another claim which is a big controversial claim. So if you're going to mention it in a very decent language, that it is alleged, and I'm using the term alleged, that often people who are practicing as lawyer in a reputed high court or some other level as a judicial officer, there is a cycle of appointment. And the Honorable Court has recognized. So it's not like that you will fall under some trap or contempt of court for arguing this, but be very reasonable. The Honorable Supreme Court has mentioned that yes, there is a question of representation here, and that is why they have come out with the idea of a resolution explaining on what grounds a person was promoted or appointed. But if a question comes, what is the problem with collegium system in India? These are the 4 points that you have to write, and I want all of you to start from here. Give the heading, issues with the collegium system. Issues with the collegium system. And just write these 4 pointers. Number 1, transparency and accountability. Transparency and accountability. In this, write, it is argued that there is lack of transparency with regard to appointment of judges, that there is lack of transparency with regard to appointment of judges, and accountability in cases of misconduct, and accountability in cases of misconduct. Right, point number 2. The second problem, there is a lack of formal criteria. There is a lack of formal criteria in judicial appointments. In judicial appointments. Full stop. Right. Even though the Constitution mentions grounds of qualification, even though the Constitution mentions grounds of qualification, there is space, there is a space left, there is space left for discretion on part of honorable judges in final appointment. On part of honorable judges in final appointment. Full stop. Write the third point. There is a lack of verification process. There is a lack of verification process to inquire whether the appointed individual has ability and integrity. And write the fourth argument. There is a question about lack of representation. There is a question about lack of representation of women and disadvantaged group of women and individuals belonging to disadvantaged groups as judges. Full stop. And write carefully, it is alleged that most of the appointed judges belong to a specific social background. Full stop. And for giving a very good argument, write Honorable Chief Justice of India, Justice Ramanna, has validated the question of lack of female representation. Full stop. During the first 37 years of Supreme Court, not a single woman, not a single woman was appointed as a judge, as a judge. Full stop. During these initial years, only Fatima Bibi, write this name, Fatima Bibi, was able to get elevated, was able to get elevated to the status of a judge of Supreme Court, of a judge of Supreme Court. Full stop. Right. Moreover, between mid 1985, between mid 1985 and mid 2010, only 4 out of 127, only 4 out of 127 Supreme Court judges were women. Full stop. Write the final statement. It is alleged that the judges working at a subordinate level, the judges working at subordinate level, or some high courts, the judges working at subordinate level or some high courts are not able to get elevated to the status of a Supreme Court judge, to the status of a Supreme Court judge. So definitely there are some serious concerns, and in order to address these concerns, the government came with a new idea. All right, any doubts so far? इसको मिटा दें. फातिमा बीवी पे यूपीएससी प्री लिख लीजिएगा. कभी कभी sometimes they ask a question from here, first female judge or Supreme Court में they ask this question, you all must remember this name. All right, इसको मिटा रहे हैं, आगे बढ़ते हैं. So definitely there are some concerns, and in order to address these concerns, the government came with the idea of National Judicial Appointment Commission. Now here there are some things which we must keep in mind. For example, if you think about Indian Constitution, definitely Parliament has certain authority by law to determine terms and conditions, but it cannot go against the basic structure of the Constitution. So what the Parliament did through 99th Amendment and the NDA government, they came with this commission. So sometimes in the main examination, because it is a question of recurring importance, so it has been asked in the main examination, and the question of transparency issue in the collegium is already an issue, so it is a recurring issue. So we have to go through this so that the preparation is done in a good manner. So what happened? Parliament appointed this commission. They thought about, let's have a commission which will address the question of how judges will be appointed, transfer, etc. So what the parliament did? The parliament did something very specific. They said that this commission will have the power, all right? So this commission will have the power to regulate the procedure for appointment. Okay, so what they will have, let's write it here, the procedure for appointment, etc. And then the commission, then the constitution states article 124, of whom CJI, other justices of Supreme Court, so CJI procedure, other judges of Supreme Court, and Chief Justice and other judges of High Court. This is what this commission will have the power. And then the parliament by law may empower this commission to frame other laws. This is what it mentioned initially. So this was the objective of this commission precisely. Article 124, which has been declared void by the Supreme Court, 124C here. So what the commission had, so who will be the members of this commission? This is the second point. If you think about this issue, who will be the members? And as far as polity is concerned, the members of commission were coming from diverse backgrounds. It was lack of, let's say, discretion on part of parliament or executive or any other institution. So as per Article 124, Clause A1, the head of this commission was Chief Justice of India. Okay, first thing. So let's say the chairperson, number one, chairperson, and I want all of you to write it so that it goes like data. CJI of India, ex officio, right? So person who is already acting as the Chief Justice of India, ex officio. First thing, Article 124, A1. Second, so not only the Chief Justice of India, two senior most judges of Supreme Court. So we have, after Chief Justice, two senior most judges of Supreme Court. And it mentions next to CJI. Next to CJI. It means immediately next to CJI, two senior most judges of Supreme Court. So if you think in terms of polity, we have judiciary coming in here. Isn't it? We have judiciary here. Let's say organs of government. The first organ that has been mentioned here is judiciary, CJI and two senior most judges. Then it moves further and it states, after this, they will have two eminent persons will be nominated. And Minister of Law and Justice as well. So you will have Union Minister in charge of law and justice. Law and justice. So if all of you recall the classes on executive, when there is a term called minister, we are mentioning about the executive here, isn't it? Council of Ministers. So here we get executive. So we are getting the third or second organ of the government. In addition to this, two eminent persons will be appointed as well. Right. So let's bring to the fourth person. We will have two eminent persons. People who are known for some work. So we bring in someone from the civil society or even from other apparatus of the state. But let's have, let's say, both. So we can have both, let's say, legislature, part of civil society, media, or let's say NGO, etc. So we have a society coming in here. society comes in. And then this mentions, and it's a very interesting argument, that as far as Article 124 is concerned, and the question of National Judicial Appointment Commission is concerned, there is going to be a committee, right? A committee will decide who is going to be nominated, who are going to be these two persons. Now, what that committee will consist of, let's look into this. So, there will be a committee which is going to decide. And this committee will include, number one, Prime Minister. So you get first to whichever house this person belongs, we get another executive here, plus this person is also leader of some house, so we get both legislature and executive in both capacity. So you have executive plus in some extent legislature. We get another organ of government here. Then in addition to Prime Minister, there will be leader of opposition. Leader of opposition. Again, coming from polity, we get properly legislature here, isn't it? Leader of opposition. We get legislature involved. Then the Constitution further states, just in case there is a possibility that we don't have any leader of opposition in the House, so a leader belonging to the single largest opposition party. So suppose this person is absent. Like let's suppose the condition of Lok Sabha today. So the leader of the single largest opposition party. So we get space to opposition in each case. Leader of single largest opposition party. Again, legislature is coming in. All right. This is how the committee will be formed. And then the Constitution states that this committee will also have Chief Justice. Chief Justice. Which means, if we think in terms of polity, we get judiciary again. So there is a balance, isn't it? Prime Minister, majority executive, leader of opposition, legislature. If this person is not present, leader of single large opposition party, again legislature, and Chief Justice, judiciary. So even in committee, we have a balance between different organs of the government. And then in order to ensure a representation of different classes, they said that out of these two eminent persons, one must belong to a disadvantaged group. One must belong to a disadvantaged group. So let's see what is meant by disadvantaged group. So as per the Constitution, Article 124, it means that this person should belong to either scheduled caste category, all right, scheduled caste. So keep writing in your copy because dictating this will be difficult. Or the person must belong to scheduled tribes, then if not any of them or all of them, the person must belong to, let's say, other backward classes, or the person must belong to a minority, and then another disadvantaged group, the person must belong to a women community. So one of them, out of these two, one must belong to a disadvantaged group. So we are trying here, the Constitution and the article is trying to have social justice. And then it was further mentioned that they will be appointed for a specific period and there is not going to be any renomination. So they are going to be appointed for, let's say, period of 3 years without the provision of nomination, so that the circle of nomination, renomination is not starting here as far as appointment is concerned. And this commission, so you can see the entire structure of what this commission included. This commission, under the chairpersonship of Chief Justice of India, will decide the process and procedure for appointment of Chief Justice, appointment of other judges of Supreme Court, appointment of Chief Justice and other judges of High Court. And then there was one more provision, that if there is reservation raised by 2 members of the commission, then that appointment will not be held as valid, or people will not go forward with that appointment. So as you can see on the board, it's a very democratic setup, isn't it? But Honorable Supreme Court considered this as unconstitutional, and there was an argument for them. So what are they trying to say here? They said, and the article goes like this, that they can recommend, this commission can recommend who is going to be appointed. Not only recommendation, the commission can also recommend transfer. Okay. So first task is recommendation, this one. Second, transfer. And third, the commission is going to ensure that the person who is being appointed or is about to be appointed as the judge of a Supreme Court or other high courts is of ability and integrity. Ability and integrity. So this was the idea behind the National Judicial Appointment Commission. If you take a moment of pause here, and if you look at the board, you can easily decipher and you can derive it that every institution of government or every organ of government is involved in the appointment process. So as far as the method of appointment is concerned, they were trying to ensure that these 3 objectives, or the question of transparency in appointment and transfer of judges, is resolved. However, the Supreme Court, in a landmark judgment, all right, this act was challenged, National Judicial Appointment Commission Act was challenged in the court, and in 2015, in a very famous case, Advocates on Record Association versus Union of India, in this case, Advocates on Record Association versus Union of India, the Supreme Court declared this act or this constitutional amendment as null and void, that it is unconstitutional. And the Supreme Court said that as far as this commission is concerned, and what was the reason given by the Supreme Court, that this is an interference in the functioning of judiciary, and it is against the principle of separation of power mentioned in Article 50. All right. So it is interference, and it is against principle of separation of power. This is the entire debate about the National Judicial Appointment Commission. Now, as far as thinking is concerned, have you all noted it down, or do you need me to dictate it? Note it down, everyone? Or is there any single student who wants me to dictate this? Because I was writing very slowly so that you people get this in this form. Done? All right. So let's keep it on the board. If it is possible, you can take a screenshot as well. So the final argument that I want to give here, as far as this appointment commission issue, it's a main examination topic, is concerned, it is this. Tell me, anywhere on the board have I mentioned about the rational or verification process? anywhere on the board, that there is some verification process in this, that there is some rationality involved, anywhere? No. Tell me, anywhere on this board have I mentioned about certain formal criterias? No. Tell me, anywhere on this board have I mentioned that there is going to be transparency? This is the question that you have to think about while writing your answer. So even though the National Judicial Appointment Commission Act is a very progressive step as far as maintaining transparency in the appointment procedure, the transfer procedure, and the promotion procedure followed in the judiciary is concerned, it is a progressive step. But the final question remains, how are we going to decide that a person is of ability and integrity? There is nothing mentioned here. Rather, it is only suggested, or it is presumed, that because there is going to be a balance of different institutions of government or organs of government in the appointment, so there is a possibility that good candidates will be appointed as judges, which is a very good step. But the final issue remains a lack of formal criteria, a lack of transparent charter based criteria explaining that these are the grounds that this person has been appointed, in addition to the qualifications needed for being appointed as a judge, like 10 years continuation without any break, etc., etc. If we think about, to conclude the debate, I will make you write one statement in the last. If we think about how to end this debate, judiciary came with a very noble proposal. So on 3rd of October 2019, Honorable Supreme Court adopted a resolution, and it said that from now onward, we will be giving information through our website about the person who has been appointed as the judge from now onward. So it's a positive step. Despite this, the question remains, and that question still remains unaddressed. So after this entire map, just write few statements. Write like this, that the creation of a national judicial appointment commission, the creation of a national judicial appointment commission could be considered as a positive step, in bringing transparency and accountability, in appointment, comma, promotion, and transfer of judges, full stop. Right? It was presumed that by constructing the commission by constructing the commission in this manner, which involved each organ of the government, and civil society, comma, question about secrecy, behind appointment will get resolved. Full stop. The commission was based more on the principle of balanced power sharing than in comparison to, based more on principle of balanced power sharing in comparison to the doctrine of separation of power, between organs of the government. Full stop. Right, next paragraph or the next point. Honorable Supreme Court in the case Advocates on Record Association, start inverted comma, Advocates on Record Association versus Union of India, Advocates on Record Association versus Union of India, bracket 2015, declared this act as unconstitutional. Full stop. In opinion of the court, and write capital T. So when we say the court, we are referring to the Supreme Court. So in opinion of the court, capital T, the court, C also capital, in opinion of the court, this act interfered in the functioning of the judiciary. Thereby against, thereby against the provision of, against the provision of separation of power the provision of separation of power between judiciary and the executive. Separation of power between judiciary and the executive. In bracket Article 50. And then write the final argument, or the second last argument. It has two parts. So final argument, first part. It is significant to mention, it is significant to mention that the balanced power sharing is not or does not give guarantee, does not give guarantee of right transparency, comma accountability, comma lack of formal criteria, transparency, comma accountability, comma lack of formal criteria, and question of democratic representation. Question of democratic representation. Full stop. And now write the final argument. Nevertheless, the resolution taken by the judiciary, the resolution taken by the judiciary on 3rd October 2019, on 3rd October 2019, regarding sharing of information, or let's say volitional sharing of information. Write this word, it's a very important word for this answer, right? Volitional sharing of information about appointment of judges is a positive step. Full stop. So not only your answer should clearly outline the problems, but it must respect the positive steps. So you must have a balanced approach, right? That is how you have to write an answer. All right, any doubts so far? All clear about National Judicial Appointment Commission? ठीक है? अब you all can write on this topic wherever it comes, whatever they ask you. What is the problem in collegium system? 4 problems. How the government tried to manage it this way. Why was it good? This thing. What's the problem? The larger issue remains. What is the radical step or forward step? The resolution adopted. 5 clear scripts argument and the answer is done. मिटा दें इसको? बहुत सुंदर सा बोर्ड बन गया, मिटा देते हैं इसको. All right. Okay, let's have, so we are already doing independence of judiciary, and within this we covered the appointment and everything. Now two more facts here. One fact is that every judge of a Supreme Court, they basically majorly they ask about Chief Justice of India. So the Chief Justice of India takes oath in front of the President or someone appointed by him. Alright. So no need to mug up, like a normal healthy understanding. Keep this in mind. This is one more fact which is sometimes asked. Coming back to the larger topic that we are doing, independence of the judiciary. The question is, there is one more factor on which the independence of judiciary is concerned. So for example, it's about financial independence. Okay? Remember in the last class I said that there are many factors on which independence of judiciary is concerned. One was how it is formed. The other was access to judiciary. Third was selection based on non-discrimination. And then comes the fourth one, independence in financial independence. So this is fourth one. So one was formation or constitution of judiciary. Then there was access. Then there was non-discrimination, three principles on which fundamentals of independence is dependent. And the fourth one here is financial independence. So if judiciary, like we mentioned, a constitutional guarantee was the topic going on, right? So within that larger framework, we are discussing it. Keep, every class is connected. So don't think that it's new thing coming in. We have a 6-day module I have in mind. Every class is connected to the next class, so that a larger idea of judiciary and pre-main interview, wherever you go, our network follows that kind of argument I'm going on. So financial independence here. Now if judiciary is not financially independent, it means that it is dependent upon the executive and the legislature, isn't it? We have gone through annual financial statement. So suppose it is not independent, it means that it is dependent upon executive and the legislature, let's say in a parliamentary setup. How? Executive is going to determine the expenses, how much we are going to spend, and then this is going to be ratified by the legislature, isn't it? So there is a dependence on other organs of the government. Now if the constitution guarantees financial independence of judiciary, then we get an independent judiciary. Alright, this is the larger argument. Now what is here? If you look at Indian Constitution, Article 125, so 124 starts with composition of judiciary, then Article 125. This deals with financial independence of Supreme Court judges. So suppose the question comes, how Indian Constitution establishes a independent judiciary. This is the fourth element that we have to discuss. Now what the Constitution has to discuss? It says that the judges of Supreme Court shall be paid salary, okay, which Parliament by law can determine, okay. So it says that they will be paid salary. Let's go like this. They will be paid salary. And the Parliament by law can determine. So legislature has a power here. So we are saying that it is dependent upon legislature. अभी ऐसा picture दिख रहा होगा, but ऐसा नहीं है. It's not like this. Then it says, until Parliament determines by law, they will be paid as per the provision of second schedule. So law here transcends from ordinary law to the constitutional law. So we are not talking about the constitution. So we have already something in the constitution. There is a constitutional guarantee coming in. Alright. First thing that we have to remember here, Article 125. And then it moves further that Not only this, so the clause 2 has something more to offer, that the judges of the Supreme Court, they shall be entitled to what? Number 1, they shall be entitled to certain privileges. All right, number 1, privileges. Number 2, not only privileges, they will be also entitled to certain allowances. Fine, good, thank you, Constitution. Then third, rights in respect of leave. Suppose they are on leave, so they will have certain rights. This is the third one that comes under. And then not just this, they will also be entitled to certain pension. If you think about UPSC, this is a current issue. So if they have to frame a question, they could frame from here, UPSC pre. This is a current question, all right? So whenever you are making notes in your copy, just write this. Pension is a current issue. The government has said that judiciary will be outside the new pension law. Now what happens here? So we have second schedule, it is connected with these as well. Then there is something more, there is a contingency fund of India. Sums that are charged or that have been put on the contingency fund of India are non-debatable. So the parliament here has to rely here, it cannot debate on it. So already there is a constitutional guarantee. But yet the constitution is saying that parliament can by law change it. Isn't it? The parliament has the power to change something. How constitution is guaranteeing financial independence comes from here as well. So definitely from time to time the parliament can change these conditions. So parliament can change allowances, parliament can change salary, parliament can change rights in respect of leave, parliament can make law on it, because we live in a constitutional democracy, and in a democracy the parliament is the only institution that has popular sovereignty. So of course parliament can do it, but it mentions something more here as well, that till parliament changes it, again everything will be governed through second schedule. Comes here as well, connected. And then the constitution mentions something very interesting which clearly establishes the financial independence of judges. So there is a condition here about the change, whether change number change according to these or change according to salary, both. There is a condition, and constitution states that after the judge is appointed, all right, so after, box it up, after the judge has been appointed, there shall be no change, all right, there shall be no change after the appointment which is disadvantage to a judge. So no change that leads to any kind of disadvantage. So what the Constituent Assembly did, or what is already going on as per the need of the hour, there cannot be any change which is against the disadvantage of the judges after the appointment. So through these mechanisms, the Indian Constitution establishes financial independence. Have you noted this, or should I move forward with the dictation? We can dictate as I can dictate as well. Right, financial independence, right? Next point, financial independence. and write like this. The independence of judiciary, the independence of judiciary is dependent, the independence of judiciary is dependent to a large extent, on financial autonomy, to a large extent on financial autonomy from the executive and the legislature, from the executive and the legislature. Full stop. Right. Next point. This is guaranteed. This is guaranteed in best manner. This is guaranteed in best manner if the Constitution explicitly, if the Constitution explicitly contains provision regarding finance related to judiciary, regarding finance related to judiciary. Right. Next point. I hope all of you have written this in your copy because through boards, so I'm going to summarize it. Right. Next point. According to Article 125, each judge of the Supreme Court, shall receive salary and shall be entitled to privileges, allowances, rights in respect of leave, and also add of absence, rights in respect of leave of absence. That's the constitutional term, comma, pension, as determined by the framers, in the second schedule, Full stop. Now write next point. Parliament by law could change this. Parliament by law could change this. Full stop. Right. However, any change should not be to the disadvantage, any change should not be to the disadvantage of the judge to the disadvantage of the judge after her or his appointment. After her or his appointment. And let me reiterate, pension is a current issue. Article 125, clause 2. Remember this, all right? In your copies, write Article 125, clause 2, UPSC pre 2000, whenever you are about to give, maybe next year or next to next year, whatever you like. It's a current issue, you must be aware about it. So, of course, Parliament by law could determine, it could change it, but because there is an element of second schedule, law here means the constitution, and then there is one more clause, there should be no disadvantage. कि अभी 50 मिल रहा था, आपने काट के उसको 20 कर दिया कि आज हमारा मूड है. No, it cannot happen. Oh God, it's just 6:30 on the clock. All right. So, any doubts so far? Clear? Topic ये भी clear हो गया? Financial independence? By law, it can change by normal law as well. But what will happen na? If they are going to bring some change in the second schedule, then that requires an amendment. But they cannot do that even. They can through ordinary law determine it. But because there is a condition of second schedule, it means that if they are changing something, they will pass certain law, certain order, and that order should not be against the larger structure mentioned in the second schedule and to the present condition in which the judge has been receiving a salary. There should not be any reduction. Of course, there are certain extraordinary circumstances when the government could do it. It could bring something new. But leave that till we are reading emergency. Till then, leave that for emergency wala part, when certain new issues come out. All right? Okay. So, isko mita de? All right. And it's 6:30 on the clock. Take a 5 minutes break. Take a 5 minutes break. I'm already, मुझे time का पता नहीं रहता ना. Take a 5 minutes break. After 5 minutes, we meet. Okay. So this was, so suppose there is a question, simple question. Can the Parliament by law determine the salary, allowances, pension, privileges of the judges of Supreme Court? Yes or no? Can the Parliament by law determine it? Change it? Yes. But is this change allowed, or to put in other words, is constitution in favor of a change which is disadvantageous to the right of the judge of Supreme Court? That's the main argument you have to take out from here. In which schedule is connected with salaries, judges allowance, salaries, allowances, pensions, right in absence of leave, etc., right in leave of absence, etc., of the judges of Supreme Court? Which schedule? Second schedule. That's it. So what will happen now? By the time we end the polity course, all these schedules will be in your fingertip, on your fingertips, like on your lips. Done. Yeah, we know the every schedule. Instead of mugging up, read through the constitution. Each and every schedule will get covered itself. Okay? Let's move forward. Now, as we have discussed, if in formation or constitution of judiciary, if appointment is fair and against any one organ's control, then we get a independent judiciary. In Indian context, we have covered it. We are done with Article 124 and National Judicial Appointment Commission debate. 2 topics covered. And then we have also covered financial independence. But not just this. What about the provision of removal? Removal of judges. Same thing will happen. If the executive has more power, judiciary will be less independent. If legislature has more power, judiciary will be less independent. But how to ensure it? So as far as the constitution is concerned, while it gives power to the executive in matter of appointment, as far as removal is concerned, it gives power to legislature. Now, 2 kind of questions are asked as far as removal is concerned. One is about the grounds of removal, and the second is about the method of removal. All right, these are the two questions that are asked from this topic, UPSC pre. One more question could be framed from here, like what is the possibility or what are the grounds on the basis of which the office of a judge could become vacant? This is another issue. Judge could become vacant. That there is an vacancy in the office. One could be this when they are removed. So we get removal here, removed by the parliament. And the other is when the judge resigns. Alright, so if UPSC asks this question from this topic, there are two answers. If UPSC asks this question, let's try to figure out what are the grounds of removal, method of removal, and then this topic will be covered as well. As far as Indian Constitution is concerned, and yes, one more topic before moving forward, there is one more topic that is connected with this. So, removal is connected with nature of tenure. If the tenure is fixed or there is a constitutional guarantee, definitely judiciary will be independent. As far as Indian system is concerned, removal is a very difficult process. It's a very difficult process. So, it is argued that the tenure of judges in India is to some extent fixed. Definitely, Parliament can determine by law, no doubt about it. However, removing someone from the position is very difficult. Not only the grounds are difficult to establish, but the method is also difficult to sustain the removal resolution or the proposed. And then it moves further. The proposed method is very difficult. We will come to it. As far as the tenure is concerned, the constitution and through law, now it is 65 years. Article 124 to 2A. Sometimes they ask this question, but it has been long since UPSC asked a question about the fixed age of the retiring age of the judge of Supreme Court. So just for the information, we can keep it here. Now, what are the grounds of removing a judge from the position of his office in the Supreme Court? There are two major grounds, okay? Number one is when it is established that the so-called judge who is about to be removed from his office is, to be precise, has been involved and it has been proven in some misconduct. First, misconduct, which means that this person used his office in an inappropriate manner for some ulterior motives which has deeply shaken the dignity of judiciary. Okay, this is what it meant by misconduct. Number one. There is another ground on which a judge can be removed from the office through the same process. Now this ground is a bit different to understand. It is mentioned in the constitution when a judge is not capable. So in condition of incapacity. For example, let's say the judge is now suffering from some disease because of which he cannot fulfill or perform the functions of being a judge of the court. So he is not capable anymore, he is incapable. There is an element of incapacity. On these two grounds, a judge of the Supreme Court can be removed from his office on established misconduct and incapacity. As far as history goes, thankfully, no one has been impeached so far. But what is the method of removal? The method of removal is a bit difficult to understand because it involves three things, or let's say two things precisely. One deals with the parliament, and within parliament, it also deals with the question of session. Definitely, the judiciary in itself can conduct an internal inquiry. It has been done in one case. Internal inquiry. Judiciary has this power. But removal is with the parliament. This is one thing that we have to keep in mind while going through this article. If the question of removal is not there, then we say that the tenure is fixed. That's why we say that in Indian constitution the tenure is to a large extent in general sense fixed. Now what is parliament has to do with it? As far as constitution is concerned, under article 124, the president will definitely sign this entire proposal after there has been an address by each house of the parliament. So both Lok Sabha and Rajya Sabha, each house. So the word mentioned here is address. So here what happens? The president will pass an order. Order after an address by each house of parliament. Now what is this address all about? Suppose in case of president's removal, we call that process impeachment, isn't it? In case of judges, often the term used is impeachment, but it is always better to use the term address here, and it mentions that this address or this resolution to remove the Supreme Court judge must be supported by a majority of total membership of that house. First thing is a majority of total membership of that house. So Lok Sabha, Rajya Sabha, doesn't matter, of total membership of that house. So whichever house we are concerned with, first condition. The second condition, as far as removal of a judge of a court is concerned, and by court here I mean Supreme Court, when we discuss High Court we will discuss that as well, and a majority of not less than 2/3 of the members present and voting. So we are talking about absolute majority here. Alright. So the second thing is a majority of not less than 2/3 of the members present and voting. Two-thirds of members present and voting. This is the second condition. So we are talking about absolute majority here. And then the third criteria is that it should be done in the same session. Now what happens when you all are preparing for this exam and you go through this article? I have seen many people not taking this word into account. The constitution is clear. There are three things. Two, as far as voting is concerned, and also in the same session. This is very important. Here UPSC can frame a question. Alright. So Parliament, President will pass an order after an address, which is sometimes also called impeachment. And this address means that it is a majority of total membership of that house, or a majority of not less than 2/3 of member present and voting in the same session. When this happens, then a Supreme Court judge can be removed from his office. The grounds are misconduct and incapacity. So far in Indian constitutional history, there is one case which is known as the case where impeachment was done, and it deals with the judge of a high court, Punjab. And so what happened in that case of impeachment, it was proposed to impeach that person, and one more judge case is there, but basically that is more famous case. The internal inquiry done by the Supreme Court found the judge guilty. Okay, this has happened. That he has used his, honorable judge had used his official position and official power to have some discrepancy as far as some kind of finance is concerned. The internal inquiry done by the Supreme Court found him guilty, but in the Parliament, because the Parliament has the power to remove, in the Parliament, the proposal or the address could not be passed. So even though they were able to have, let's say, total membership, etc., but a party in Parliament decided to be present, but it remained absent from the voting process. So they were present, members present, but they abstained from voting. So 2/3 majority could not be achieved, and therefore impeachment was not done. The third thing in this is that a judge can resign as well. Simple, writing under his hand, and this must be submitted to the president. Alright, simple. So there are three questions that come from here. I hope all of you have noted down in your copy as well. The first question is the tenure of judges in India fixed? So if you go with an objective answer, the tenure is not fixed. Okay, we will go with this. Suppose the question is changed. Is the tenure fixed till some age? We will say yes, till 65. Suppose the question is changed, that is it not possible that before achieving the retirement age, a judge can be removed from office? They will say no, it is possible. There is a method of removal of judge from the position of Supreme Court. Or other court as well. Today we are discussing Supreme Court, so we will focus on Supreme Court. The second question could be, what are the grounds of removal? This is the first question. The second question, grounds of removal. There are two grounds. One is misconduct, the second is incapacity. Then the third question would be, what is the method of removal? Simple, these three. Here also you have to remember, one is about the majority, the second is same session. And then the fourth question could be, what are the situations or circumstances when an office of a judge could become vacant? Number one, when that person is removed. Number two, when that person resigns. Any doubt? Clear? Do you need to write this? You want to write? Okay. लिखवाना है इसको? All right, write it down. Right. Removal, right, removal and vacancy in the office of judge of the Supreme Court. removal and vacancy in the office of Judge of the Supreme Court. Start writing. Am I audible or is there a problem in the camera? Just let me know if there is any technical error. Audible, na? Okay, thank you. So write like this. As per the first point, write like this. As per the Indian Constitution, as per the Indian Constitution, executive has no role to play in the removal of the judge. Then write second point. In general sense, is it fine now, Tejas Vyasvi? If I'm right in spelling your name, pronunciating, yeah. Is it fine now, Tejas Vyasvi? All right. So we move forward. In general sense, the tenure of the judges is considered as fixed. Full stop. Write in extension that the parliament can determine the parliament can determine the age limit for a judge by law. Okay, by law. Full stop. And before full stop, in bracket write article 124 clause 2 2a. 124 clause 2 2a. 2a. And then in extension write at present the age limit is 65 years. Write article same 124 clause 2 also you can write clause 2. Article 124 clause 2. Now write next point. This one. Misconduct and incapacity are the two grounds on which a judge of Supreme Court could be removed from the office. Okay, a judge of Supreme Court could be removed from the office. Within bracket write article 124 clause 4. This one. Article 124 clause 4. Now write the removal, next point, the removal is based on a difficult process. The removal is based on a difficult process. Full stop. Write in extension. The president passes an order after an address. The president passes an order after an address passed by, write number 1 in it, a majority of total membership of each House of Parliament, right? A majority of total membership of each House of Parliament. Second, a majority of not less than, 2/3 of the members present and voting. A majority of not less than 2/3 of the members present and voting. And write third point, in the same session. In the same session. So 3 criteria, which means one is about the majority, absolute majority, and then it is about the same session. Then write next point, the office of the judge, could become vacant through removal and resignation by the judge. Through removal and resignation by the judge. Resignation, write another sub-point beneath the resignation, write the judge of a Supreme Court the judge of a Supreme Court may may resign from his office, by writing under his hand, submitted to the, underline this, submitted to the President of India. Submitted to the President of India. And within brackets, same, Article 124, Clause 2, 2A. Article 124, Clause 2, 2A. And then write the final point. The judiciary is equipped. The judiciary is equipped to conduct an internal inquiry. To conduct an internal inquiry. All right? Done? लिख लिया सबने? Let's move forward. चलो इसको मिटाते हैं. So now we are talking about judges. So let's talk a bit more about judges. Let's have some more articles. What kind of judges are there? So a quick, and few parts are left in independence of judiciary. We will deal that later. Now we can talk about judges here. A new topic is starting here. So quick question. How many judges are there in the Supreme Court? Option number 1, 33, 34. Option number 1, 33, 2, 34, 335, 436. एज लिमिट का है मंजोत 124 क्लॉज 2 65 years को लिखा है. How many judges are there in the Supreme Court? My question is very simple. 33, 34, 35, 36. Correct. How many judges are there in addition to the CJI? Now what will be the answer? Correct. बिल्कुल सही पकड़े हैं आप लोग. Good. ठीक है. So we have the beautiful judiciary here. चलिए आपका प्री का एक और सवाल ठीक हो गया. You know the number of judges at least. Now there is this person CJI, and then there are other judges, right? We have covered this much. And here we have the entire debate of collegium system. We have all the 3 judges cases. This is how we have studied today, in previous classes as well. 3 judges case. Then we have the question of transparency. We have the question of accountability. We have the question of formal criteria, and we also have a question of representation. All right. Then we had the topic National Judicial Appointment Commission. And then we had this volitional resolution adopted by the Supreme Court. And then we had a normal suggestion. This is what we have done. Apart from other things. But यही किया है ना. ऐसे तो बनाओगे कॉपी में खट you have the pointers with you on the right hand side of your notes वाला copy. So always do like this. But there are some other positions in the court. We are talking about the judges, so let's look at the other positions. One position is, suppose this person's office is vacant. There is a vacancy in the office of CJI. That vacancy could be through either removal or any other manner, incapacity or something. So a new office is created, which we call the acting Chief Justice. Okay, in your copy, go like this: the acting Chief Justice. Okay, this is one office. Then there is another office here. So not only acting Chief Justice, we also have ad hoc judges. Okay, और बढ़ा देते हैं इसको. एक ये लाइन यहाँ हमने खींच दिया. Then we have ad hoc judges. Let's go like this. Ad hoc judges. अस्थाई judges हो गए. ठीक है. Let's have a line here. Then we will add one more. Let's deal with these 2. Then we move on to the third one. Now, as far as this position is concerned, the Constitution and especially Article 126 states that whenever the office is vacant, so we get the first question here. Whenever the office is vacant, number 1, first problem, first ground. The second is, or the Chief Justice, this person here, the CJI, is unable to perform the duties. Alright, this is the second criteria or second ground. Now the Constitution states not only unable to perform the duties, the reason could be any. So the person won't be able to perform the duty because the person is absent, there is an absence, or otherwise any other reason. Alright, so there can be many reasons. In this circumstance, you will have as far as Indian judicial system goes, an active Chief Justice. Alright? So we will have a, let's say, ACJI, Active Chief Justice, ACJ. Now the question is, who is going to be the ACJ and who is going to appoint him? The person who is going to appoint the ACJ or Acting Chief Justice is Mr. President. The President will appoint. And who is going to be this person? This person is going to be the senior most judge, or let's say such other judge of Supreme Court. Such other judge of Supreme Court. It means from here we get the acting justice. Usually what is the norm? The senior most judge becomes the acting chief justice. Senior most judge. Okay? So in your copy, write like this. I don't think we need to dictate it. I want you to make it like this. Have you all written it? Yes or no? लिख लिया सबने ये अच्छे से? इसी तरह से, just like this you have to make the graph here. Huh? Now we have another category of ad hoc judges. Only focus for the examination. Don't go into too much detail. So what happens here? So here we have, let's say 1 and 33, 34. So at least you need half people, na? Or let's say at least 10 to conduct the business or 7 to conduct the business. Sometimes what happens that due to, let's say, absence or some other reason, वो भी तो बीमार पड़ते ही होंगे ना, they must be falling sick. What happens due to these kind of reasons? There is lack of quorum. Huh? There is a lack of quorum. So the first thing which Constitution tells is that there is a condition in which we can have ad hoc judges. Huh? First thing, when there is a lack of quorum in the court. Here we have 126, right next article, 127. Now lack of quorum to do what? What is the purpose of quorum here? The Constitution defines that there is a lack of quorum to hold or continue the session of the court. Two things, to hold or continue the session of court. Alright, this is what Constitution states. When there is this lack of quorum for these two purposes, we have the provision in the polity about appointment of ad hoc judges. Now what is the process? The process is very interesting here. What is the process of appointment? So the first person who is involved here is the Chief Justice of India, CJI. And the second person who is involved here is the Chief Justice of the concerned High Court. So one is CJI and then let's say Chief Justice of the concerned High Court, CJHC. They both are involved. What this person has to do, Honorable Chief Justice? He has to consult the Chief Justice of the concerned High Court. Alright, first thing, there is a consultation involved. Now what this consultation is all about? Keep on writing like this. In your copy you will have a very good map chart. So what this consult is this, that he consults the Chief Justice of High Court and requests in writing. Okay, the Constitution is clear that there has to be a request in writing. अब ये नहीं बोलना आपको कि फोन कर देंगे. No, there is not going to be a telephonic conversation. He has to request in writing for the attendance. For what? What is the purpose? What is the purpose here? For the attendance in sittings of the Supreme Court Supreme Court of India. Okay, let's have it here. And what this judge is going to do, like when he is going to consult that of a judge of this High Court. So, attendance in sitting of Supreme Court of whom, bring it here, not the Chief Justice, but judge of the High Court of which this person is the Chief Justice. So, judge of some High Court. Okay. So, he will request in writing. And for the time period, if this person accepts, definitely he should accept. If this person accepts, so for that time period, this person will be considered as an ad hoc judge. But there are certain duties he has to perform. There are some duties. First duty, and let's say it goes like this. Now this person is already judge of a high court, so he has certain tasks in his own jurisdiction area. Chief Justice of High Court has talked to him, he has conveyed message to the Chief Justice of India that yes, this person is available, bring him in. This person has the duty of priority. What priority? That he will consider and he will put all the works that are assigned to him when he is going to act in capacity as an ad hoc judge. He will put this work above any other work. Number one. And he also gets certain authority. So till this entire time period, he will receive something. Alright. So what this comes? So he has to attend the meetings, he has to attend the sessions, etc., etc. And for that entire time period, this judge will get the allowances, powers, privileges, jurisdiction of the judge of a Supreme Court. So he will get the powers, privileges and jurisdiction of judge of Supreme Court. So this is what is ad hoc judges, which is like very important when there is lack of quorum. There is something more. If you read the Constitution, the next article, Article 128, is about retired judges. Okay, judges who have retired. So it goes like attendance of retired judges at the sittings or sessions of Supreme Court. Okay, so attendance of retired judges at sittings of Supreme Court. This is Article 120. So how many judges we have? We have a CJI, we have other judges, then we have acting Chief Justice, then we have ad hoc judges, and then we have retired judges here. But there is a problem in this. So don't consider this person as judge of the Supreme Court. Let's have a strict separation here. Keep this person separate. Isko thoda alag rakhna hai. Why I am saying this? It will become clear in a while. So, number one, definitely who can appoint? Here, CJI is involved and President will have something to offer, but Constitution is basically mentioning CJI is going to work upon it. Here there is something else as well. Definitely the CJI, but after taking the previous consent of the President. So the first thing is CJI after taking previous consent of the President. Now remember, the name suggests itself, the devil is in the detail. It's already mentioning about retired judges. So these judges have already retired. So what happens here? Number one, who could be those judges who can be appointed as or whose attendance could be required at the sittings of Supreme Court. Number one, they must have held office of Judge of Supreme Court. Number one. At the time of independence, before independence, we did not had a Supreme Court, so they must have held office as judge of a federal court. The second condition. Very good. Then, through an amendment, a third condition was added. It was suggested that this person must have been or held office of judge of a high court. Okay, so must have held office judge of a high court. But remember, if you follow article 124, it is specifically mentioned, and same will happen here as well. There will be one condition that is same here. They must be qualified to be appointed as judge of Supreme Court. Same goes for here as well. Same condition is applicable here as well, that the so-called judge here must be qualified to be appointed as a judge of Supreme Court. Otherwise, he cannot even have an ad hoc position. So it is taken for granted. Now what happens here? They are required to fulfill the attendance requirement. So what is their task? Their task is to sit and act as judge of a Supreme Court. And be very careful with the words. This is what the Constitution is mentioning. To sit and act as judge of Supreme Court. And keep this word circled. Act. So they have to act. Acting karna hai. And then it moves further. Every such person who are retired here, number 1, number 2, number 3, every such person, when they will be requested, they, after giving their consent, so post consent, they will come and sit and act as the judge of a Supreme Court. But they will have the allowances not like them. They will have allowances which President by order determines. Okay, number 1, which President by order determines. And it moves further to say that they will have all the jurisdiction and, let's say, powers of judge of Supreme Court. So here they are similar like this. Same thing is going on. So jurisdiction, powers, privileges of judge of Supreme Court. But they will not be deemed to be judge of this court. So unlike them, which gets the position of ad hoc judge, they will not be deemed as judge of Supreme Court. The reason being, they are already retired. So these are different kind of judges which are present in the Supreme Court. Chief Justice of India, other judges, acting Chief Justice, ad hoc judges, and attendance of the retired judges at the sitting of Supreme Court. If we move further, let's say article, so you have written it or have you not? ये लिखा सब लोगों ने, ऐसे ग्राफ बनाया अपने अपने उसमें कॉपी में? Good. So this is how you should keep these articles in your copy. एक ही पेज पे आपको 4 मिल जाता है ना, ज़रा बेहतर होता है. If we move further, Article 129. Article 129 declares Supreme Court to be a court of record. Very simple. Article 130 is about seat of Supreme Court. Very simple. If anyone asks you in the UPSC examination, where is the seat of Supreme Court located? Answer is Delhi. Can we change it? Answer is yes. It can be changed. How? Time to time it can be changed. The Chief Justice of India can determine time to time such places where Supreme Court seat should be situated. Okay, so who is the authority here? CJI. But he can only do so after approval of President. As simple as that. So from Article 124 to 130, this is what is there in the Constitution. The moment we reach Article 131, we are now entering the domain of the entire judicial structure and role of judiciary in the governance. Okay, think like this. So till here, we had composition of judiciary, internal judiciary parts, etc., etc. But from Article 131, we begin with the original jurisdiction. All right. Then Article 132, we reach appellate jurisdiction. And then the sequence goes on till we reach the article of rules of court of Supreme Court. So in the next class, we will begin with the judicial structure in the governance. We cover all these jurisdictions. Basically, there are, let's say, simple, how many jurisdictions are there? One is original jurisdiction. Second is appellate jurisdiction. Then there is an advisory jurisdiction of Supreme Court, presidential reference, etc. on matters of public importance and law. Then there are writs which Supreme Court can issue. And then there are some special powers or a special jurisdiction of Supreme Court, which includes special leave by appeal. Then there is an article on how to do complete justice, which is very important for the main examination. We will cover that. And after this, in 1 or 1.5 class, we carry with the topic of judicial activism in Indian polity, how judiciary has worked on this activism. We will also discuss whether judiciary has extended beyond its zone of influence. And if judiciary has done it, volitionally or non-volitionally, if the Honorable Court has done it by mistake also in some matters, and if it has not done it, if it thinks that it is doing right for the polity, then also what kind of challenges are emerging in the Indian polity. So because you will be part of an executive, you must be aware about the challenges that are emerging from this kind of interference in zones of different organs of the government. Till then, thank you. We meet next Thursday. All right? Okay, thank you. Clear so far? Any doubt in the class? Done with Article 125 to 130. Okay. See you all on Thursday. Thank you.